State citizen entering this plea could subject you to deportation or otherwise affect your immigration status. There are mandatory court costs that I have to impose on your case. By entering this plea, you've given up your right to have a hearing as to the reasonableness of those mandatory court costs. Do you understand that?
Yes, ma'am.
Now, I see that you're taking Risperdal and Trazodone. Other than those drugs, are you taking any other kind of drugs, alcohol, or any other kind of medication, including over-the-counter medications such as Tylenol or anything like that?
No, ma'am.
All right, so tell me what you take these two medications for.
Bipolar depression and sleep.
Okay. When was the last time you took them?
This morning around 3:30,
All right.
the Risperdal.
Okay. And what about the Trazodone?
Last night, around about 9:30.
Anything about your mental health issue or any sleep issues you have that are keeping you from understanding what you're doing here today and the consequences of what you're doing?
No, ma'am.
Anything about these drugs that are affecting your ability to understand? Anything that has gone on, anything you've talked about with your attorney or anything else like that?
No, ma'am.
All right, and I'm going to put on the record, this is probably about the third or fourth time that I've seen Ms. Hudson. She's appeared in front of me either via Zoom or in person for various status hearings since we arraigned this case a couple years ago. And her eye contact is normal, her speech is normal. She is shackled, and while she's standing at the podium, originally she was in the jury box, seated in a chair. When I came in and we were ready to take this plea, she walked herself from, even shackled, from the jury box over to the podium, which is about a distance of about 20 feet, and nothing in her gait or anything else was unusual. Her speech is normal, and I have no concerns whatsoever about her ability to enter this plea and her understanding of the consequences of doing so. Do you have any concerns at all, Ms. Schlemmer?
I don't, Judge.
All right. Now, was Ms. Schlemmer able to review the sentencing guideline score sheet with you, and did it appear accurate? Do we have one?
Your Honor, I have working on the amended one, so I will forward it to.
Does she have any prior record?
She does, Your Honor. She has some felonies to include grand theft, third degree.
All right, well, I need to be able to go through that
Yep.
with her,
I'll pull that.
so when you get that ready, let me know. While that's being prepared, Ms. Hudson, do you understand you're going into a prison sentence, okay? So here in the state of Florida, we have a prison releasee reoffender statute. So let's say you get out of prison, whenever you do, and you commit another crime within 3 years of your release from prison, okay? That could potentially subject you to mandatory sentencing on that particular new crime. Do you understand that?
Yes, ma'am.
And in addition to that, once you're able to review your score sheet, what you need to understand is that if you commit a crime in the future, even if it's beyond the 3 years, so it's not dealing with the prison releasee reoffender statute, but just beyond the 3 years, and hopefully you won't, but if you do, these charges are going to be scored on a future score sheet and will make a future sentence greater. Do you understand that?
Yes, ma'am.
Do you also understand that in addition to the special conditions of probation, which I'm going to announce on the record, these that are listed, you're going to also have to comply with the standard terms and conditions of probation, and those I don't announce on the record, but you must still follow those. Probation will let you know what those are when you meet with them after you're released from Florida State Prison. Do you understand that?
Yes, ma'am.
All right, thank you. We'll just wait for the score sheet so I can make sure you reviewed it.
It's okay. He's doing good. He was sad when I told him over the phone. Yeah. What is a good seed?
Some sort of reason, maybe a health reason, maybe, or something, I have no idea. But they apply for clinic.
Record, I'm thinking
Yes.
All right, Ms. Hudson, did you have an opportunity to review the score sheet that basically lists what the lowest permissible prison sentence is?
No.
Did you look at that?
No.
All right, she needs to see that.
You're making it hard on me here, Jess. How do I get this up and down? Oh, there we go. How do I get it back up? Yes, how do I get it back up? This is that score sheet we talked about. It's
Going through a computer that has potentially, I didn't see it, but the score sheet on it, were you able to review it and discuss it with Ms. Schlemmer?
yes.
Did it appear accurate to the best of your knowledge?
Yes.
Do you understand that if you commit a crime in the future, in addition to what we just finished talking about, these charges will make a future sentence greater?
Yes, madam.
All right. I'm going to find this plea is knowingly, voluntarily, and intelligently entered, and that the constitutional rights have been knowingly, voluntarily, and intelligently waived. I'm going to accept the plea. I'm going to ask the state to give me a brief factual basis in support of it.
On or about June 29th, 2024, 4-year-old Joseph Hudson was found unresponsive at approximately 4:30 in the morning. He was transported to St. Joseph's Hospital and was pronounced deceased at 5:51 a.m. During the course of the investigation, law enforcement observed several contusions to his arms and torsos, as well as a large abrasion to his side. The medical examiner conducted an autopsy and determined that the cause of death was blunt impact injuries of the head and torso, including laceration of the liver with bleeding in the abdominal cavity and in the pelvic organs. They also determined that injuries to his face had been covered using some form of makeup. Interviews were conducted of individuals, including 2 children, ages 9 and 14, who were also in the home at the time of Joseph's passing. Those interviews revealed that Ms. Hudson would direct the 9 and the 14-year-old to hold Joseph while she proceeded to hit him and kick him with her hands, feet, and shoes. At certain points, his hands would be up against the wall while his head would be hitting the wall during the beatings. Ms. Hudson provided a statement where she indicated that the boys were not responsible for any infliction of injury to 4-year-old Joseph, and that she herself was the one who inflicted the injuries that ultimately led to his passing. All events occurred in Hillsborough County, and she can be identified.
I'm going to find that there's a sufficient factual basis to support this plea, and pursuant to your agreement with the state, once again, I'm going to adjudicate you guilty on each count. I'm going to sentence you to 40 years in Florida State Prison. You will get credit for Is it still 785 days? 785 days that you have served thus far. I'll impose all mandatory court costs as a lien. In addition to the standard terms, and the 40 years will be followed by 15 years of probation pursuant to your agreement. And the letter dated August 9th, 2026, the following special conditions will follow and be part of your probation. And that is, you will have no contact with any child under the age of 18. A court may approve supervised contact with a child under the age of 18 if the approval is based upon a recommendation for supervised contact with a child under 18 and is issued by a qualified practitioner who is basing the recommendation on a risk assessment. You should also not visit, work for pay, or volunteer at any school, child care facility, park, playground, pet store, library, zoo, theme park, mall, or other place where children regularly congregate. If a court has approved supervised contact with children under the age of 18 based on a recommendation issued by a qualified practitioner after a risk assessment has been conducted and a psychological and mental health assessment and parenting course have both been successfully completed, then supervised visits to such locations may be permissible with prior approval of the probation officer. You also shall submit to warrantless searches by the probation officer of your person, your residence, or your car. Within 30 days after release from incarceration, you will enroll in and thereafter successfully complete an anger management course at your own expense. If you have taken one within 3 years of your release from the Department of Corrections within a Department of Correction facility, that will count as, and you can show that certificate, that will satisfy this condition of your probation, but it has to be within 3 years of release. If you take one, listen, as many of those you take, I've always thought therapy was good for everybody. As many of those you take, great. But if you take one in the beginning and beyond 3 years before your release, well, that may be good for you. It is not going to satisfy that condition, so you're going to have to take one again within 3 years of your release so that you remember the course. Also, people change those courses and they may get better over time, so it's not going to hurt to take another one within 3 years of your release, but that will satisfy that condition. If you have not taken an anger management course within 3 years of your release from the Department of Corrections, you will successfully complete one while you're on probation within 2 years of being on probation. Within 30 days after your release from incarceration, you will submit to a psychological mental health assessment and shall follow through with any treatment recommended by the evaluator at your own expense. You will complete any recommended treatment within 3 years of being on probation. So same thing as far as the anger management course with the psychological or mental health assessment. If you've had one at any point within 5 years of your release from the Department of Correction and have completed all recommendations that have been suggested by a mental health or psychological expert based on that assessment within 3 years of you being released from the Department of Correction, that will satisfy this condition of your probation, and you will not have to redo it while on probation. You will present yourself for random testing for the presence of drug or alcohol at the request of your probation officer. You shall pay an additional court cost of $151 for crimes against minors. You shall also forfeit to the Tampa Police Department all evidence seized during the investigation of this case, and you will pay cost of investigation in the amount of $327.96 to the Tampa Police Department. You shall also pay cost of prosecution. This is in addition to the standard court costs of $100. And all standard terms and conditions of probation also apply. All right, Ms. Hudson, do you have any questions at all about the sentence I've just imposed?
No, ma'am.
All right, and also I'm going to suspend costs of supervision for the first 6 months after your release so that you can get acclimated into the community. All mandatory court costs can be also completed pursuant to while you're on probation. You can try to work those off through community service work at a rate of either $10 an hour or minimum wage, whichever is greater. That's completely up to you, because these liens, they continue to grow with interest and they can affect a lot of aspects of your life. So if you want to work those out through community service work, I'm providing you that opportunity to do that since you're indigent and have been represented by the Public Defender's Office. All right. I'm also going to recommend that while she's in DOC, she be permitted to enter and try to complete any educational, vocational, or faith-based programs that may be available to her. Those are just recommendations. DOC does what they think is appropriate. Do you understand that, Ms. Hudson? All right. Thank you. You have no other questions?
No, ma'am.
All right,
I do
yes.
have one thing. She
Yeah.
can't get 40 on count 2, so I talked with Ms. Covertier. Can we do the 40 followed by 15 on the second degree murder? And then the act child abuse can only be a 30?
All right.
Running that concurrent to the 40.
All right, not a problem. So the 40 followed by 15 applies to count 1. As to count 2, I'm sentencing her to 30 years in Florida State Prison to run concurrently with the sentence she's serving on count 1 with the same credit for time served on that. There will be no probation to follow on count 2. That's only applicable to count 1. All right, anything else?
One clarifying thing, Your Honor, Ms. Schlemmer and I had spoken within the last couple of days about contact with MH and AA. They are under the age of 18. We are including them in the no contact provision for anyone under the age of 18, including while she is in custody. Obviously, once they turn 18, it will be up to them at that point.
All right, so the no contact with minors or people under the age of 18 apply to her 2 other children, and that applies as of right now. Obviously, once they're 18, if they want to have contact with her and she wants to have contact with them, that's a different story because they'll be over the age of 18, okay? Anything else?
I just want the record to reflect this was a death penalty case. The state had filed notice of intent on first degree murder.
Okay. You understand that, Ms. Hudson?
Yes.
All right. All right. Good luck to you, ma'am. You're going to be fingerprinted over to my left. Thank you, everyone. Want to bring in the jury?
Just thinking, I don't know if the state planned on using some photographs this morning that I had an objection to.
Okay.
These are part of Exhibit K. When I reviewed the evidence, these were a separate exhibit. I think the state combined them after
Okay.
I reviewed them, so if I can just approach just
Sure.
review. And it's a basic 403 objection, as well as at this point, very cumulative, and they're essentially photographs depicting the deceased on the ground in the kitchen. We've seen, I think, 3 or 4 body camera videos showing the exact same thing. There are some other photographs that I did not object to of her on the ground. So these photographs specifically, I think, are just cumulative and some gruesome.
Why shouldn't I exclude those under 403?
Yes, Your Honor, so for these photos in particular, as to the positioning of her decedent, it's important in this case to show where she fell as it relates to other testimony to corroborate other statements of where she was standing in the kitchen when she was shot, as testified yesterday by Ms. Nora Banks. So as relations to that, to show, like I said, the positioning of that, and again, just to show the injury and which relates to our burden of proof and our cause of death.
All right, but the injury, I've already approved of autopsy photos that are gonna come in, and you're gonna have a medical examiner describe the injury. We've had some description of the injury already, because we've heard numerous body-worn camera, we've seen videos that have audio on them, and we hear the police officer, in fact, I think it might have been Sergeant Rhodes, we hear him talking about, because he does a look for the brachial pulse as well as the carotid pulse, and we see that on the video. We see her body in the video. I believe I've seen other crime scene photographs that also have her depicted in the video, and we heard the testimony of Miss Banks' mom, the mom, and where they were in the kitchen and all of that when Mr. Banks came forward and shot her in the head. And so I don't find that those photographs that you're holding are, while they may be probative, frankly, I do find them cumulative. I do find that there's not only body-worn camera, but other photographs that depict those same injuries and her positioning. And we do know autopsy photos are gonna come in that are going to aid the medical examiner in describing her injuries, and therefore I find those cumulative and prejudicial, and I will grant the defense request to exclude those.
Understood, thank you.
Sure, not a problem.
I have a stipulation to identification.
Okay,
So we're going to request that you read that, and I think there's an instruction that goes with stipulations.
yeah,
And then there's another instruction that we talked about last night.
yeah, the edited recording.
Right,
Let me ask you, when are you gonna call your ME?
first.
Oh, he's the first, so I'll
Yeah.
read that as soon as they said, I'll do the edited recording first, and then I'll do the stipulation, and then you'll call your medical examiner.
Okay,
Okay.
sounds good.
And
All right.
she just put on the record, Judge, that yesterday when we were off the record, you reviewed the autopsy photos along with Ms. Schlemmer and Mr. Harmon. We had an objection to some of those. All of the ones that the defense had an objection to have now been removed from that stack of photographs. I just
All
wanted
right.
to make sure there's a record of that.
Yes, we did do those off the record. The court reporter had turned off her computer. We all agreed we would address them. We did. And exactly what Ms. Dunker just represented is what's happened. And so the autopsy photographs that are going to be admitted today are admitted without any further objection. Is that correct, Ms. Dunker?
Yes, and I should just also note, although we were off the record, Mr. Banks was still present.
Oh, that's correct. Mr. Banks was here throughout that entire discussion yesterday after we had sent the jury home.
So Judge, the photos are states in as in November
Okay.
1 through 7.
All right, so states N like November, as Mr. Harmon just said, 1 through 7 are admitted without any further objection.
Also, it's not already in removing for O to be admitted, it's just the projectile from the victims. Ed,
We don't have any objection to that.
All right, and States Exhibit O will be admitted as well, which is the projectile that was recovered from the victim during the autopsy.
Judge, I also wanted to let the court know, we're gonna rest this morning at some point before lunch. I'm very
Wow,
hopeful.
okay.
Very hopeful. We have Dr. McKinnon, I'm sorry? Yeah, now I have Dr. McKinnon, now, Ms. Schlemmer is crossing, so, I don't know.
I don't-
Might be in the afternoon,
She is crossing, but I don't think this is one of those cases where the cause of death is an issue.
It'll be very.
Scissors.
Don't worry about it, you gotta do what you gotta do.
I
I'm
want that
just-
stricken from the record.
He's cracking a joke in the morning.
So I have, we have Dr. McKinnon, possibly Detective Tamargo for limited testimony. Detective Hill will be fairly lengthy.
Okay,
And a crime scene technician, that's gonna be somewhat lengthy. And then Monique Polisi, if necessary, who's a latent print examiner.
got it.
So maybe it's hopeful, but I'm hopeful we'll rest before noon.
All right,
So just to let the court know, that's
okay.
kind of the schedule.
The only thing we've got left to go through for us to actually do anything with the jury as far as deliberating is we've got to finalize the instructions.
Right.
I've been going through them. So I'm gonna send all of you the copy that I've been working on and take a look at some of the things I've done. One of the things I did, just so that you can look at it, is I tried to see if I could combine the introduction to homicide and the introduction to attempted homicide into one. So
Okay.
I'm not reading the same thing twice, okay? If you all read it and you prefer it
Yeah.
separate, I will do it separate, but I wanted both of you to see how, or all three of you, or four of you, to see how I combine them and see if that's gonna be acceptable.
So Judge, the other thing I wanted to point out in those instructions, the attempted murder of a law enforcement officer, using the standard instruction and directions from the Supreme Court website, I added those last three elements, and then I incorporated those as factual findings under Erlinger in the verdict form. I think the defense should have them, but I guess we can discuss that at
Yeah,
that
we'll
point.
discuss all that, okay? All right, everyone, we ready for me to bring in the jury?
Yes, sir.
All right, let's get the jury in here.